Hello everyone. It is Halloween Day 2016. However, this video has nothing to do with Halloween. It's purely a coincidence. It was about a week ago that I did my civic duty and reported to the Van Nuys Courthouse for jury duty. I was at the courthouse for 3 long consecutive days. On the first day, I sat in a very large waiting room with about 90 other prospective jurors waiting for my number to be called. Well, it was not called on day 1. Day 2 was very similar. I sat in the very large waiting room and my number was not called. On day 3, my number was called along with a group of other jurors, and we were escorted into another room where we were interviewed by a prosecuting attorney, a defense attorney, and the presiding judge for a specific trial. The interviews were individual, but not private. They were very public. And after I was asked a few questions by the 2 attorneys, the judge very politely dismissed me. He told me I had fulfilled my jury duty and I was free to go home. I was free to leave. Well, I have to tell you, I was absolutely delighted. I could hardly wait to get home and tell my wife the good news. I was not real happy about being called for jury duty. And in retrospect, the judge probably did a very wise thing dismissing me, given my very negative opinion of the trial by a jury of one's peers. Jury trials are highly flawed on many levels, as I will explain now. First of all, let's look at the word peer. What is meant by the word peer in the phrase, a trial by a jury of one's peers? Can the legal definition of peer be that different from the Webster's English Dictionary definition? Webster says that a peer is someone from the same social group based on status, age, or grade. In other words, an equal. Now this brings up a very interesting question. Are my peers the same as my wife's peers? Are my peers the same as my grown son's peers? Are they the same as my neighbor Steve's peers? How can this be? A jury of my peers would consist of 70-year-old retired males who had retired from a trade, who were not college educated, who had been married for many years happily, and who had grandchildren. This would truly indeed be a jury of my peers. So how does our legal system go about selecting a jury of my peers? Well, it is done at random, from DMV records or voter registration records. So a jury of my peers might consist of everyone all the way from a single unwed welfare mother, all the way up to a full college professor, and everything in between. In fact, there might not be one of my true peers in the whole group. This is just one problem. Another very serious problem is that the jury is not there voluntarily. They have been conscripted. This can create great havoc in their personal lives and with their financial responsibilities. What about the family surviving on a single paycheck? What happens to them when the paycheck is suspended? How about the elderly infirm individual who must arrange public transportation every day just to get to the courthouse? How about the college student who has studied hard all year only to find he will miss the final exams because he will be on jury duty? Does anyone really believe that an individual plucked from his or her financial responsibilities and daily life can really devote themselves wholeheartedly to the task at hand, which is determining guilt or innocence? Wouldn't they subconsciously want the whole thing to be over with quickly? I know I would. Now, what are the qualifications necessary to perform this very vital function and to sit on a jury? Is it an elementary school education? Is it a high school diploma? Is it a college education? No, none of the above. It's very simple. You have to be 18 years of age or older. You have to speak just enough English to understand what's going on, and you have to have not been convicted of certain crimes, and that's it. And armed with these very impressive qualifications, the jury is supposed to decipher and make sense out of very complex forensic evidence that modern science can provide. It's no longer a simple case of the accused fingerprints being found at the scene of the crime. That's too easy. Today we have DNA evidence, we have blood splatter analysis, we have autopsy evidence, and ballistic evidence. And all of this evidence is filled with scientific concepts and technical terms. Now, perhaps realizing the average juror is not going to be able to interpret and make sense of this kind of material, both the prosecuting attorney and the defense attorney hire their own expert witnesses to bolster their own cases. For instance, the prosecuting attorney may hire an expert witness who will testify that the accused DNA was found at the scene of the crime. It's very damning evidence and should be admitted. While at the same time, the expert witness for the defense will claim the DNA was collected incorrectly, it was contaminated, and therefore not admissible. Now, how in the world is a juror supposed to make sense out of such conflicting testimony? Well, the truth is that the so-called expert witness is really a travesty and should be ignored. For a price, an expert witness can be called to refute or debunk almost any theory under the sun. The juror can really be thought of as a pawn, like in a game of chess. And pawn status is determined immediately when the prospective juror is interviewed by the prosecuting attorney, the defense attorney, and the presiding judge. What they are looking for is somebody who is malleable, somebody they can manipulate and change. They don't want anybody with life experience leaving them with strong opinions, with strong convictions. In other words, the emptier your head is, the better they like you. It was right after my interview that I was politely dismissed by the judge. A very puzzling thing about a jury trial is that although the jury is responsible for determining guilt or innocence, it is not allowed to ask the accused any questions directly. Everything the jury sees and hears during the trial must be carefully filtered and spun by the two attorneys. And of course, there's no guarantee these two attorneys will be equally skilled or equally matched, and often they are not. As a final indictment of the trial by jury, consider this. If you are the plaintiff in a malpractice case or an accident case, you definitely want a trial by jury, not by arbitration. In such cases, it's very easy for your attorney to bring the jury around to an unrealistically high settlement by tugging on their heartstrings. Yes, juries are susceptible to emotions like pity and empathy. And of course, emotions should have absolutely no place in purely determining guilt or innocence. Okay, that just about wraps it up for the trial by jury. My shop assistant, Mr. Dillon, who made a brief appearance a few frames ago, and I both thank you for watching, and we welcome your comments for and against. We would especially like to hear from an expert witness to refute or debunk some of the opinions expressed in this video. That's it for now, folks. See you again next time.